And also there are agreements with um, players that make um, handsets. So what do each of those agreements do? Well, the one with Apple is a revenue sharing agreement, and the others are revenue sharing agreements. What isn't disclosed in the decision, but came out during the course of a hearing with one of the witnesses in November last year, is that the revenue sharing agreement with Apple is a 36% revenue sharing agreement. So Apple gets 36% of Google search ads revenue from Apple users. That gives Apple $20 billion a year, and 20 billion reasons, if not more, to promote Google search and search ads. Apple has blocked pretty much all data from all Apple devices on the grounds of privacy, except to Google, because obviously Google search ads are based on Apple users' searches using Google search. And that revenue sharing agreement creates an incentive to promote Google over any rivals. So one of the things that the judge looks at is, well, there isn't much competition in search. Well, it's very difficult to have competition in search. So Apple didn't build its own search capability. It did look at it, and there's internal documents that are disclosed in the decision where it was actually beneficial to Apple, in Apple's interest, to use Google, because Google search is already built. It includes a huge advertising system which funds it. The European Commission decision said that it was running at a capital cost of about 1 billion a month. It's slightly less in the court's decision in the USA versus Google, but there's obviously an exclusionary effect on Apple from building its own search engine. There's an exclusionary effect on the installation of Bing or any other search engine on Apple devices because of this revenue sharing agreement. The revenue sharing agreement also contains a default setting. Now, I'll come back to the default point in a moment. So all of the other agreements are similar. They promote Google search products on the basis of revenue share and default settings, whether that's to a telecoms carrier, a manufacturer, and those people who follow European law will see great similarities in this case with the European Commission's Android case, which also said, look, these are anti-competitive agreements. But I think the reason I've been emphasizing the revenue sharing aspect is that when you look at the incentives on Apple to promote Google, and by consequence of promoting Google, then to demote rivals. Apple's incentives, if the revenue sharing continues, would be exclusionary. Whether you have a default setting or not, it doesn't matter whether there's a default. You can ban the default, but Apple would still have an incentive to promote Google because it gets 36% of all income that comes off the back of Apple devices. So that's clearly a fundamental problem. And that's what's driving what the court also established as a main issue here, is that Google has been raising prices for many years in advertising because it could, because it's not facing any competition. And so if you want to look at the next stage, which is what do you do in terms of remedies, which you'd probably come back to, you need to do something about the problem. So the problem is to stop, the classic way of remediating an antitrust problem is to make sure that the problem is stopped. So what's the problem? We need to identify, and I've said it's revenue sharing a default setting. And then you need to prevent it from arising in the future. And you also need to remediate the position in terms of competition so that the market that's been distorted is put in a position where it would and could become competitive in the future. So my basic point would be that you need to do something about the revenue sharing. That should stop. The default setting should be stopped. And then there should be an opportunity for the market to correct itself and new entrants to come in, including Apple, to do search. We can come into more detail about what that means. Just as a footnote, by way of introduction, the Australian ACCC has already said that the default setting agreements between Google and Telstra and Optus and one other telecoms company in Australia need to be amended. And they've said that they've got undertakings that say, well, we're going to banish the default. my point there is if you don't do something like the revenue sharing, you haven't really solved the antitrust problem. But just by way of introduction, that's basically what the court has looked at. They've found a monopolistic position in search text ads. It doesn't really matter how you define the market, but for US antitrust purposes, that's a very narrow market. Google monopolizes that, raises price, and the mechanism that it's using um, to exclude competition is revenue sharing and default setting agreements across the board.
Yeah,
Thanks.
thank you so much, Tim. I'll come back to you. Now I come to Orly. Orly, Tim has already taken us to various issues with the default setting, the bunch of agreements, be it the RSA or MEDA. But I want you to take a step back and tell us bare facts. I mean, who were the petitioners involved in this case? And there was also a lot of discussion around this question of relevant markets before sort of monopolization power or exclusionary effect came into the effect. So if you can sort of take a step back and tell us about bare facts, what were the core concerns of the petitioners, and yeah, and then you can from there you can build it up.
Yeah, thank you. Well, thank you so much for having me first, and thank you for this great introduction. I think it's just laid down the discussions very well. Everything that Tim has mentioned, like revenue sharing, I think all this is totally fine in the market. Like you have a lot of companies that do revenue sharings for placements or for default settings. All this is fine unless you have a monopolistic position, right? And so the main thing is why are we not allowing revenue sharing or default positions or exclusivity agreements? Well, it's because of the very position, dominant position of Google and how we define this market, which is essentially, I mean, everybody will agree because the searching on internet, as we just say we Google it, right? So it has become even the name. So it's pretty rare for a company to become so dominant that it becomes a verb, right? So it's just obvious. And it's not so much of getting into a monopolistic position that is illegal under antitrust laws in the US or even under European competition law. It's sustaining that monopoly and extracting further monopoly rents from that monopoly position. It's not so much about being dominant. If you want to be dominant because of innovation or high quality, that's fine. But the main thing is using those default settings, exclusivity arrangements, and particularly the revenue sharing agreements in order to cement a monopolistic position. That's the semantic aspect, or what in the DMA they say the entrenchment. It's the entrenchment of the dominant positions over the years that is very much problematic. I think that is the real thing. Of course, Google had many good arguments, to be honest. Like, what's the counterfactual? You know, the fact that on Windows, on Bing, people may search for Google search engine, so they tweak the default settings. Yes, default settings are steering consumers in status quo bias, but it's not 100%. If you have a very bad product, at some point the consumers will switch off, right? But there's a brand loyalty as well. That's what the Judge Mehta explains, that it does explain a lot of things. It does not explain everything, the default settings, because you can always switch off. So you have to have some sort of good product, right? The fact that Yahoo is a very bad alternative, of course it helps Google, right? The fact that the competitors are not that good, that even reinforce the default settings. And that's not Google's fault to offer a higher quality product, but it's Google's responsibility or problematic practice to pay its way out of competition. And that's what I want to focus on in here. You know, we heard a lot about killer acquisitions, like buying out competitors, like the financial power in order to buy out competitors through merger and acquisitions. Here is a little bit of the same thing, the revenue. You buy out in order for your competitor not to compete with you. And that is mostly like what Tim referred to, is you incentivize Apple not to launch its own search engine. And so you kind of, the most competitive alternative or competitor, which potentially could be Apple's search engine, you try to incentivize them financially, not only on the product and quality and consumer choice, but you incentivize the competitor not to compete with you. And that is the most problematic aspect. So I agree with Tim. I think the revenue sharing has to stop because that's the most problematic thing. In terms of default exclusivity, I think because of the market position that Google has, I think we are heading towards more like screen choices, which is the most common solution under European regulations with the Digital Markets Act. Then it creates another issue. Screen choices between how many? 4, 5? How do you pick those 4, 5? So it creates another kind of path dependency bias where you have only those 3, 4, 5 search engines that are offered to the consumers. So I think it's a very first, the ruling itself is very well argued, very well written, it's very well articulated. I think a lot of people have recognized that in both sides, pro plaintiff or pro defendant. So the ruling itself is very illustrative and very informative. It's a landmark cases in the US because we have so few monopolization cases. The last major one was, of course, Microsoft. And it tells you that in the new era of like digital market, we can have default settings, we can have exclusivity, but you cannot pay your way out of competition through some revenue sharing and financial incentives that deter competition. One thing that the Microsoft case precisely was the unbundling. This is more than the unbundling between Internet Explorers and Windows. This case of Google, it's not about a technical solution. It's a financial solution that needs to be found. Like the unbundling or the lack of default won't be enough. And that's what is very interesting over the last 20 years from Microsoft, where it was only a technical solution, and Microsoft like, okay, you just unbundle, and then we're good to go. Here is like you can read, because of course the decision doesn't talk about the remedies, so there's a lot to discuss yet. But you can read between the lines that it's not only the technical default or user interface that needs to be changed. That's not only it. That's like 50% of it. The remaining 50% is the financial incentives. And that is very interesting because if you put that also in perspective of the killer acquisition aspect, there's an increasing notion that you cannot buy your way out of competition. That's how I get it from the mergers, killer acquisitions, or from those monopolization cases. There's an aspect like you become powerful, you become financially successful, right? Because they have a lot of cash, but you cannot use this pile of cash to deter your competitor to compete. That's how you can interestingly make the connection between merger, the trend in mergers with the new US merger guidelines, at least in the US, and these cases. And something as well in other cases, like the Siemens, some monopsony or no poach agreements, when employers pay each other or like agree to each other not to hire employees. So there's an element of like you cannot conspire with your competitor and convince your competitor by financial means. That is kind of, I wouldn't say it's new to antitrust, but it's a revival approach that it's interesting to see in the digital markets.
Yeah, thank you so much, Orlin. I think what I understand from what Tim has stated in conjunction with what you have said, I think these revenue sharing agreements with Apple sort of lie at the core of this dispute. And I'll come back to it. Before that, I would like to go to Shinawat now. Shanawat, as we know, I think in the last conversation also we did touch upon that in the Europe, we already have the Digital Markets Act, where we have these sort of ex ante rules. However, when it comes to the US, we are relying on the current antitrust framework, right? I mean, would you like to shed some light, I mean, on this judgment? I mean, how would this be of bearing to the sort of emerging markets, right? In the Asian context, be it India or be it, let us say, Thailand, or let us say any other Asian jurisdiction. For instance, South Korea is also an emerging economy. So if you can shed some light on that.
Okay, yeah, thank you very much. And yeah, thank you for having me here. And I totally agree with both speakers, as Tim and Ollie. Yes, before I start discuss about the Asian point of view, I might lay some point that I totally agree for to the both speakers. I might have a slightly perspective on this case. I think the default option is quite the big issue here as well, because back in the past, if you look at how long that Google has adopted the default options conduct, and that I think that built the monopoly power of the Google for a long time. And that is one point. And I totally agree that the revenue sharing is the serious concerns as well. And especially when the Google is the dominant position in the market. But look at for what we have discussed is the court might look at Apple as an competitor in the market, but if the Google look at the Apple as a partner, what will happen? Because the Apple hasn't start the search engine, right? Or they development or stop. I'm not sure, but yeah, I think yeah, the Google has some good point to defend itself, but yeah, I think the main point here, because if you look at because maybe I'm from the behavioral economics area, so the default option is one of the most powerful choice architect techniques out there. People barely switch from the pre-installation default setting. And yeah, maybe the Google said that there is no counterfactual, but if you look at other similar study on default option, the default option is very effective choice architecture techniques. That is my point. Look at the Asian. I think that maybe we learned about the DMA that there is a Basel effect that will spread over the world. The way we look at digital market are different now after the EU launched the DMA. And I think this case is one of the precedent case that will affect how we look at the case or how other jurisdiction will treat competition conduct in the digital market. Yeah, I think yes, that the main point. The remedy, I think we will back to it later. Okay.
Yeah. Thank you so much, Shinawat. So, Tim, I'm just thinking out loud that, in the UK, we already have this DMCC, which is Digital Markets Competition and Consumer Act, right? Is there any likely interface? Because what has happened precisely in this judgment is that the district court has applied the extant legislative framework, which is applicable in the US, which is mostly ex post, right? And then basically come to a finding that, Section 2 of Sherman Act has been violated. Do you see this judgment sort of playing out on this entire conversation between ex ante versus ex post? Any thoughts on that?
Yeah, sure. But before I do that, I'd like to come back on a couple of points.
Yes.
The first point, which I think it's easy to overlook, is that what the Google machine does is it turns consumer data into advertising dollars. Now, how does it do that? Well, the why it does it is because that's how it makes money, because it's free at the point of use, so it's funded by advertising. The how it does that is it takes all of the data from your previous search histories, your browser histories, and every interaction with every Google product. And as it was said in the course of the trial, the magic of Google, they have a set of slides called The Magic of Google, comes from consumer interaction and feedback, right? This is very important because when you're looking at remedies, it's not just the revenue sharing agreement, which actually creates the relationship with the end user. That gives Apple an incentive to give Google search ads a promotion, right? But the interaction is then between the end user and Google. So if you want to remediate the position, obviously you've got to stop the agreement, you need to ban the default. But to remediate the position, there has to be a new interface with a third party and an end user, right? There needs to be a new mechanism by which other search engines get to interact with end users, because without their interactivity, you're simply going to reinforce Google's dominance, right? So they turn user data into advertising dollars. Now, the reason that's so effective is because it understands what you're looking for in commercial searches. So if you're looking to buy a new hairdresser or washing machine or lawnmower or a new cricket set, whatever you might like to think of, Google will know that and be able to put an advert up that's relevant to your queries. So anybody that is going to compete with Google in that space needs to know what you're interested in, right? So they need to get access to data about what you're interested in. That's what's foreclosed through these agreements. And that's what gives rise to the opportunity to raise price. So I just wanted to bring that out. It's a consumer interface, but it's also an advertising relationship. So what Google's doing is taking consumer data and turning it into advertising dollars. If you want to create competition, you have to create the ability for that to take place through somebody else's engine. Now, one way in which you could do that, and I just also want to pick up on what Aurelian was saying. Yes, you're absolutely right. Since Microsoft, and I do have the honor of acting for Microsoft back in the day on the defense side, yes, choice screens were used to unbundling, but they didn't work terribly well. And the choice screen, I know it's been adopted in the DMA, but facing consumers with a choice of things that they find irrelevant or annoying doesn't really get you home. The problem, if you think about the problem as that interface, the interface comes from the first page that you land on. So if you look at what, you go to an Apple website, you go onto the Apple store, Apple could create a search engine results page and use Google's relevance engine in the background. An access remedy would enable you to do that. And the reason I put that forward is because you would then have Apple users interacting with a search engine results page, possibly from Apple, possibly from third parties. And the remedy is a different thing in law than the finding of liability. So what people often do is to say, well, if here's the problem, then here's the solution. So if the harm has been caused by this, then you mirror the harm by reversing it. So you mirror the problem is the default setting. Well, it's not, right? But if what you do is then mirror it by banning the default setting, that's kind of something of a solution, but it's not a solution because it's not addressing what the harm really is. The harm is the foreclosure of access to the end user data through the revenue sharing agreement. So what you need to then put in place is a mechanism that says, okay, we're going to provide this mechanism. We'll come back to your DMCC point. I haven't forgotten it. So what's critically important then is that you're getting access to the data. Alternative third parties have got the use of it, but one of the harms basically is generated by that magic of Google, the interactivity. So creating some form of interactivity would also be a potential solution. The reason that's possible in a US court setting, and I'll draw a distinction in a minute with the DMCC, is the court has the ability to impose remedies. And one of the things the DOJ has asked for is equitable remedies. Equity provides them with a very, very wide discretion. There is a new case, there's a filing from the Federal Trade Commission against Google in relation to the App Store last week, which is extremely interesting because the Federal Trade Commission is saying, look, this is an injunction. We've got the opportunity to impose interoperability remedies and a wide scope of remedies under US law, which stops the harm, right? So you identify the harm, you stop the harm, you prevent its reoccurrence, and then you do something which enables competition. Because the harm is not to the individual or the third-party competitor, it's to competition, the competitive process. So there needs to be a mechanism through which there is redress to the structure of the market in this case. So DMCC, does it do that? Well, it's got to go through a process of designation, which is where we currently are. It's intended to address the problem of scale and scope and network externalities that big platforms have got. So it's intended to do that. And yes, it does have both conduct requirements, which are behavioral remedies, and what's called pro-competitive interventions, which are structural remedies. And we've had those remedies in our law for a very long time here in the UK. We recognize that the great reward for success is that you create a monopoly in capital, in the capitalist system, you end up with a monopoly and you need to be broken up because that's not in the public interest. So that happens pretty frequently. I'm from the telecoms world. I lived through the AT&T breakup and the dismembering of AT&T into a series of regional bell operating companies, and then it was reformed into a slightly different structure. Here in Europe, we liberalized telecommunications and separated out different functions and capabilities and allowed businesses to operate in that way. We have a very good remedy to this problem, which is a potential precedent is the BT OpenReach precedent, which I had spent a lot of time on, which separates out the monopoly from the non-monopoly components, which is exactly where we currently are with Google. So what we've done in local access and long distance and systems integration and computing, those are all layers on top of the underlying telecoms monopoly, which is separated out. As I say, that's been a very long history. The US, the breakup of AT&T in 1984 was preceded by a 1956 decree which required the quarantine of AT&T, so it couldn't do computing. You could apply the same approach if you're a US court towards the browser or the search engine and quarantine the browser or the search engine. So there's plenty of precedent for a much broader set of remedies. There's going to be a hearing on the 6th of September in Washington, which I'm planning to be in Washington to attend. But anyway, those are just back to your points that picked up what Aurelian was saying, and also, where we're going in the UK from the DMCC point of view. Thanks.
Yeah. Only any concurring or sort of differing thoughts, and I mean, most importantly, again, this question is very important because what are the possible remedies which the DOJ might ask against Google? That is one, and equally important, what might be the foreseeable grounds on which Google might file a challenge against this.
Yeah, I think it's perhaps from a comparative perspective, like comparing the US and Europe and how this kind of ruling can apply also throughout the world. It's kind of interesting, as Tim mentioned, like Google shopping case in Europe. It's kind of interesting to see the culture, the legal culture, which is very different. When you read the cases in Europe, you really have a feeling that it's public law, it's administrative law, it's public order. When I'm referring to that, it's like Google Shopping, they refer to the quasi public utility or essential facility doctrines. Like Google has a super dominant position, has a kind of specific responsibility that it has to behave as almost like a public utility. You have to yeah, it's like you have to be non-discriminatory. You have to avoid, like there's this sense of like you've reached such a place, a dominant position, that you have to treat your competitors, suppliers, and distributors, whatever, in a neutral way. That's the such neutrality, or whatever you call it, platform neutrality. In the US ruling that we have here, it's very different. You can still feel the antitrust injury, the harm, looking at contract. It's a very contractual, private law type of reasoning. This contract is the revenue sharing, is the extractions of monopoly power, and therefore it's this kind of contractual arrangements are kind of wrong. And so it's interesting to look at to what extent the US ruling will have also for other companies will have a greater, as we call it in legal terms, like erga omnes effect. That needs to be seen. Because what you see in Europe is like it's meant to be a public ruling for all types of companies and all types of interactions of Google's with its suppliers, competitors, and whatever. Here, with the US ruling, is perhaps because of the common law philosophy and legal culture, it's perhaps limited to Google and Apple and Samsung's kind of type of ruling. Yet it doesn't mean that it won't have a greater effect. So it's very interesting to see that we still regulate this kind of monopolistic positions from two different types of legal culture, even though the effect or the outcome is the same. It's also very interesting to see that in Europe, we haven't. Also like it raises questions like why we haven't talked about this kind of revenue sharing, why we haven't talked about why this kind of billions of dollars of revenue sharings has never been raised, either in Google Shopping or Google Android or Google Ad Text, never raised. And that's like the.
Can I just come back on that?
This is the kind of elephant. Yeah, is the kind of elephant in the room that needs to be addressed. Yeah.
Just to come back on that, because I think you raise a really interesting point. I've been involved in working for people who've been affected and adversely affected about this. I think there's a very good reason. I'll come back on your other point as well if I can. So the very good reason for that is revenue sharing isn't new or special or different. The reason why it's suddenly become so obviously and dramatically exclusionary is because of the amount of profit that's generated. So in Apple's case, it gets 36% of Google Ads revenue, right? That's a big number, $20 billion a year. But it's an even bigger impact on its economic incentives when you realize that, as it's put in the judgment, when you look at the revenue share in 2020 and 2022, that amounted to 17.5% of, because that's at the time the court was looking at it, 17.5% of Apple's net profit. That's more money from Google than Apple makes from making Mac computers. So the incentive on Apple is enormous because of the relative impact on its bottom line of the income from Google, which has, by the way, gone up, because that number is 2020, 2022. We're now in 2024, and the revenue sharing it's probably still 36%, but even on that basis, it's a higher proportion of profit because the revenue, the amount of money has gone up. So it's the impact, and that we have not seen before, and that's because of the process. So your point about the difference between Europe and common law, the difference in the US is that they're taking a process which is a court process. We do have a common history and culture. So the common law is based ultimately on Roman law, and what we're talking about here is a tort. It's a civil wrong, it's a tort. So antitrust everywhere is a tort. Now, in medieval England and medieval continental Europe, these were all treated as torts, and it was regarded, Thomas Aquinas talked about this as a sin. If you sold outside a marketplace, it was a sin. It's the reason we have market towns. And we had engrossing and forestalling as common law torts. They were abolished many years ago. And that then gave rise, so if you look at the history of antitrust, that gave rise to the modern administrative system, which was proposed by the Austrians and the Germans, the administrative system of policing the tort law, which is the harm to others from trading, which only happens when you've got a monopoly position, because obviously all the things that you can do can be done if you haven't got a monopoly position. But when you do have a monopoly position, you harm others, you harm the community. So you're quite right. There's a different philosophical basis, because in the States, they have a prosecutorial system and we have an administrative system. Even in the UK today, we still have an administrative system from the European base. The prosecutorial system, I would suggest, is more effective at getting to the truth, though, because it's only in the prosecutorial system that we've uncovered not only the nature of the revenue sharing agreements, but also their impact on other people, right? So that's
exactly
massive.
True. That's exactly true. Like how in the Google Shop, it's a, I mean, I won't say it's a failure, but it's a big miss for the Google Shopping case, for the Google Android cases in Europe. Like it's just like we talked about Samsung, the manufacturers, yeah, the Android folks, all these discovery processes.
And it's like the same. We've got the same problem in the mobile. There's a mobile browsers inquiry in the UK at the moment, and in the schedule to the working papers, they talk about, oh, there's revenue sharing agreements. And it's only because of the US case that we can go back to them and say, hey, have you looked at the revenue sharing by comparison with profit, and then look at the impact on those players? And I did an inquiry into telecoms a few years ago, and I asked one of the telecoms players, what can you do that would make the biggest difference to your business? To which the answer was, get a bigger amount of money from Google on search, sell more search, because that's my biggest income stream. I was astonished. Nobody knew.
Yeah. No, but it's a question of like evidence, like a discovery process. I think we can also in Europe, but also it works for India and other countries. Like you can't get to the bottom of the case unless you have a strong discovery process. Just looking at like talking about the algorithm or how you're ranked in the Google search, I mean,
hopeless.
Really, no one cares. No one cares, right? I mean, it's just like there's like a superficiality in something that we talk sometimes that is not really at the bottom of the case. What is unseen or to be discovered is the kind of revenue sharing or this kind of financial incentives that we don't see, we don't know, and that should be part of the court system. And that's how precisely sometimes the common law or court-based system is kind of superior to the administrative system where we just rely on like prima facie type of evidence. I think also this ruling is well argued, well argumented, because there was a strong discovery process. And that is what I also wanted to say.
Very true.
Yeah. Arun, you have actually raised a very interesting point in relation to the legal culture, and I mean, Shina, but I'm just thinking it. I mean, how would this, this question around legal culture will play out in the Asian context? Because I mean, in some cases, we say that we are a group of emerging economies, right? However, when we bring the legal culture into play, I mean, this is just a totally different factor, right? So how would this play out in the Asian context? And second part to my question is that also, as Tim correctly pointed out, that violation of competition law is a public wrong, right? These are not in personam offense; these are in rem offense, right? So I mean, what should be the what is the likelihood when it comes to Asian jurisdictions around this question of legal culture?
I mean, talking about India specifically, I think one big advice I will give, and I think it's we live in a world of increasing populism everywhere, and we don't like the court system. We want things go fast because they grab headlines, something like. And I think India is also based on the common law system, and I think it's very important to distinguish the time. The time of the judiciary and the time of the politics and the media. I think in order to have a strong finding that can have a lasting effect, it's very important for Indian courts and the discovery process to take place and see what are those revenue sharings, how are Indian manufacturers, distributors, what are their relationship with Google? Not just like looking at trying to transplant the European case or the US case to India, but what is it in practice? And I think the US, they haven't copied and pasted what was in Europe. It's precisely as Tim meant, it's like they started from scratch. And now it's the UK being finding some inspirations from the US. I think you have to start from scratch the whole case and looking at what's the specific relationships and what is the revenue sharing, what are the contractual arrangements. And that's why it's mostly, even though it's a public wrong, it's a private injury, private tort, and private contractual arrangements that you have to unearth and you have to decipher and find. Unfortunately, I may say, India has been very much into the trying to politically use the regulation of tech companies or regulations of things for political purposes. There's been some elections recently. I think it would be great to disconnect what we want politically with the funding on the rule of law. And I think that's the greatest challenge of today's regulation of digital markets, because everything has become political, where it should become rule-based and discovery-based. And at the end of the day, it may not be the most timely interventions, like going fast and with that type of ex-ante type of regulations, but it may be the most meaningful and impactful for consumers, right? As you mentioned, timely interventions, choice screens, whatever, would it make a real difference for consumers? Not really. Breaking up the revenue sharing agreement, that would make a difference. And I think that's the two kind of things. Do you want a quick regulation that force some screen choice without looking at financial incentives, without looking of just dismantling this kind of financial incentives? Or do you want a real discovery process where you tweak the financial incentives? And one solution is very quick, very fast, politically rewarding and attractive. And one is very slow, it's judicial based and more impactful. I would prefer the latter one.
Sorry, just to hold on a minute. I'm not convinced that the court process is slower than the administrative process. At all. I think the court process can be faster than the administrative process, because if you take into account the fact that the basic problem here is there's an information control, information disadvantage. So those people who are harmed don't understand why. They're living at the bottom of the garden and they get data and it's like rain. It allows them to grow, but they don't really understand how it gets there. And if somebody who controls the garden is controlling the gate and whether it rains or not, then you've got a problem, which is what we've got with a Google and Apple walled garden situation. So there needs to be an investigation. The administrative system takes a long time because it doesn't do discovery. It asks questions. And, I've seen the very fantastic difference between the US process, where you have litigators who are people who are skilled with law degrees and experience of doing litigation, that understand that it's in the interest of the party responding to the question not to give perhaps a full response, that they depose people and they ask people for evidence to support their responses. Whereas the European and to some extent the UK system is bedeviled by questionnaires, which you can fill out to greater or lesser extent depending on as a defendant, depending on what you want to share. And the underlying documentation, if you don't get to it, what people did, why they did it, who made what decision at the time, what evidence do they have for making those decisions, if you don't get to that, you don't get to the truth. I think the US system and the Indian and the UK system do share a common history. And, where I think there's perhaps a wrong turn is the US takes the Assistant Attorney General Antitrust, which creates a specialized function within the Attorney General's office as a litigator to protect the public interest. That, again, goes back to common law hundreds and hundreds of years ago. There's always been an Attorney General. And there's an Attorney General in the UK, and there's an Attorney General in India and Australia and other places. That public interest scrutiny could be brought to bear by simply a stroke of a pen, by giving the Attorney General greater powers to prosecute. You also have the Federal Trade Commission, which is an administrative body in the States. So you have both in America, where you have a political or quasi-political system and you have a prosecutor. So you don't need to have one or the other. You could have both. And so if you're looking at the broader aspect, I think one big example, and I think it's great to have come out of this conversation, is that yes, the European Commission did act slightly more quickly, not very fast, but slightly more quickly, and missed how the revenue sharing agreements operate, probably because
So
it
I
didn't
think,
do full discovery.
yeah, Tim, I think Shinawat has something to add.
Yes. Actually, maybe I'm not a good person, the right person to answer the question because I'm not a lawyer or the professor in law. So yeah, but I could share some point that we are discussing. In Thailand or Asian countries, I have heard we are trying to applying ex ante regulation in the near future to help prevent anti-competitive conduct. Because I think it's quite similar in what happened in the EU. We believe that if we use the ex post, it might be too late to recover the market. So I think most of Asian countries now is looking at ex ante regulation one way or another. And yeah, back to the administrative and maybe I can say the criminal court. In Thailand, there are both systems installed in our law. So I can share that it's for Thailand perspective, which is not quite long. The criminal law is very challenging for the Thai authority because we need to go to the court process, deal with a general prosecutor of the country. But in administrative law is slightly quicker because we can decide we can make the decision ourselves. We have board, and then the board can make the decision ourselves. So I think Thailand is the criminal law case is quite challenging. It's much more difficult to proceed comparing to administrative cases. That my point of view.
Yeah. So, I mean, I'll just share a bit of Indian perspective. So, I mean, we are in the process to sort of have a law on the lines of the DMA. We call it the DCB, which is Draft Competition Bill. And the research which we conducted in the center showed that the current legislative framework, which is ex post, what we call as the Competition Act, is obviously is sufficient to an extent of identifying the anti-competitive practices, be it the bundling, be it the tying, or be it self-referencing, or let us say cross-utilization of data. However, one prime question which is being continuously raised in India is that how timely is the intervention is, and most importantly, what is more worrying is that when it comes to the question of quantifying damages, when it comes to awarding compensation, right? Even though there is a legal provision under the Indian competition law, it's virtually dead because in the last 15 years when we have enforced Indian Competition Act, there has not even been a single award which has been awarded to the parties for competition violation. So yeah, this is to put the Indian the update from the Indian side in a very brief manner, so as to say.
If you want a quick result, what you do is you apply for an injunction, and the fastest mechanism to get an injunction is to go to a court. And the reason why it's faster than an administrative process, always and forever, is that appealing a court's decision for an injunction is very, very hard. So in the UK, in English courts, the judge is ordered under the practice direction to make a decision normally within 3 days. I'm quoting the practice direction. I was a judge for 5 years. And so you normally have to grant your injunction very quickly. It can be vacated. You can have it applied simply on the evidence of one party. And then when the other party comes along and says this shouldn't have been put in place, it can be taken away. But that happens every day up and down the country and in every commercial court, in every tortious case. That happens all the time. If somebody's being harmed, the quick way of intervening is a injunction. And I'm using the expression injunction to mean equitable injunction from a court. It's actually quite different from an administrative act for interim measures, because any administrative act has to involve the gathering of evidence, the weighing of evidence, the gathering of evidence from the defendant, the gathering of evidence from everybody else, and it always takes too long. Right? That's your basic problem with administrative acts. And it's the fundamental problem with the administrative process modeled on the Brussels system, is that it doesn't have an equitable remedy. There is a remedy from the European Court of Justice. The last time it was used was in relation to Hasselblad, which is in the late 1970s. So it's not much overlooked as a remedy. So if I was wanting to move quickly in India, I would say, yeah, but use the courts and go for an interim injunction, not interim measures.
Yeah.
So thank you so much. We are coming to the end of it. So I think, Audrey, you can sort of give concluding remarks. We are at the end of it, followed by Tim and then by Shinapati.
Yeah, just very good. I think the last interim injunctions in Europe was the Broadcom case in 2019, where they revived this kind of interim measures. But totally right. I mean, the DMA, when it comes to going quick, it was to go quick with compliance measures. Then those non-compliance measures are being challenged in court, which is going to take years. So at the end of the day, it's like either you go to court first or you go to court last, but it will take time. And that's true that administrative measures take time, because at the end of the day, they are challenged in court. So why not going to court first? That's totally the point, and I totally agree with that. But just going back to our discussions on the US versus Google case and ruling, I think this is just as a conclusion, this is a very well-written decisions. I think it's a very useful also to know the understanding or the knowledge of judges or US antitrust in the 21st century, 20 years after Microsoft. It's good to have, like, because of new theories like potential competitions, barriers to entries, economies of scale, scope, that haven't been discussed sufficiently in US federal courts under Section 2. And more generally, I think it's a well-balanced decision. Question is about remedies. And I think the remedies need to be found in the contractual arrangements, and the financial power needs to be tamed, in a sense that you cannot buy your way out of competition, and the revenue sharing is a considerable incentive not to compete. The default setting, competing about default setting over innovation and competition and quality, it's fine, But even though it's more problematic, of course, depending on your market position. If you have like if 10% market shares and you have default settings, that's fine. If you have 80% market shares and you have default setting, that's very problematic. But the most problematic, as Tim mentioned, is the financial incentives. So it's very interesting to see that what is a revenue sharing? There would be no revenue sharing at all, or what if there's a tiny little commission? Would it be kind of fair? So that's the kind of thing that would be interesting to look when it comes to remedies. Is revenue sharing per se, because of this monopolistic position, unacceptable, illegal, or a revenue sharing that is like, I don't know, 1% or rather than 46%? I don't know. I think will lead toward all types of revenue sharing, given the fact that Google has become a verb when it comes to search engine.
Yeah, thank you so much, Arlene. Tim, concluding remarks. What are the implications for the board?
Yeah, look, I mean, I think revenue sharing is not something that's ever going to be per se illegal or which is automatically problematic. It depends on the impact that it has on the incentives of the other party. So if I, agree to sell coffee in my law firm, I get a percentage of the number of coffee sales that take place in my canteen. It's hardly going to make the blindest bit of difference to the success of my firm. So it's not really a problem in that sense. It is a problem here where Apple was developing its own search engine, investigated, costed, has the technology. You know, it's probably the most and the best placed player on the planet to build a search engine from scratch, and has investigated. We've got evidence that it did think about doing that, but was foreclosed from doing it because it did a financial analysis saying, well, we make more money out of having a deal with Google. So in these particular circumstances, it's clearly problematic. It's problematic because it contributes to the bottom line in such a big way. It's a profit generator of enormous proportions. Where does that take you to? Well, you know, Tim Wu, former presidential advisor to the White House, did an article last week in the New York Times where he was talking about creating a a separated search engine or a separated browser. And there have been reports in Bloomberg from Leah Nyan and from the New York Times saying that the DOJ is currently considering breakup. I think that's an entirely reasonable place to go, because if you had a separate search engine or an independent, quarantined search engine, for which they have precedent under the AT&T 1956 decree, you can quarantine an activity and you can make a determination in equity which remedies the position going forward. So if you had a relevance engine that was quarantined and many different people could resell the relevance engine, you could create competition in search, which is the underlying problem, that at the moment there isn't competition in search engine results. There isn't competition between the results pages of different players. And that's something that could be a remedy, and that would solve the problem, because the interactivity would be between the search engine results page and the business that is turning that interactivity and that data into advertising dollars, which would solve the underlying problem. But hey, you know, that's for future debate and future discussion. One thing I would say is that I think it's very important to have these types of discussions publicly. I think that the authorities are listening because they know that they have got it wrong in the past. You know, previous decisions and breakups haven't worked very well. And so getting it right now is going to be a politically important legacy for any of the authorities that are dealing with it. This isn't just the Department of Justice. There's a parallel case in AdTech taken by the European Commission. There's a parallel case in front of the CMA. There's parallel cases. You've seen the ACCC in Australia, and their decision is clearly defective. I mean, to me, the ACCC has done is a mistake, and I hope they have the self-confidence to go back and look at it again in the light of what's going to happen. Hasn't happened yet, but what is going to happen in the States in terms of remedies, and hopefully the US will get it right, because that affects an entire generation. And this isn't just for ad tech, this is for everything, because we buy pretty much everything online. So all of consumer purchases are affected by all of this. So this isn't just a sideshow for antitrust or a side dish to eat. You know, it's actually critically important for all consumer purchases online.
Yeah. Shinawat, if you can share some thoughts, concluding thoughts.
Yes, I think, what we have discussed today is very interesting points. And yeah, we still need to discuss more, looking at from different perspectives. What I like about today is, we discussed about the revenue sharing, which is problematic in some certain point, if I correct. So when the monopolies can incentivize competitor to not to compete, it will be problematic. And antitrust law or competition law, the main objective is to make sure that people have choices and there is still a competitor come to compete in the market. So I think go back to the default option. Why I think the default option is the starting point of the problem here, because people cannot freely choose at the beginning, and that makes the problem even worse. When combined with the revenue sharing, this makes monopoly getting more power in the market and make this the effect will hit the consumer and other businesses in the bad way. So I think that yes, and I think in the future that when the remedy comes, we still have some issue that we can discuss later on.
Yeah. So thank you so much, Shanawat. So I think what really lies at the core, my understanding of this entire conversation is that revenue sharing agreement, default setting, where sort of Google is the default search engine as well as in certain cases the default browser, lies at the core of the dispute. What we were also able to discuss is that what could be the effective side on remedy. Is it the administrative side or is it something which lies on the judicial end? I think Orlin also brought in the point of legal culture, which is also very important, and this remains to be seen how this sort of plays out in the Asian context. So I think this conversation is ongoing. We know that the remedies are yet to be awarded. The remedies are yet to be imposed. And also, we do not know would Google appeal the decision. Mostly, it would. What would be the grounds on which an appeal would be filed? So, but again, thank you so much, Orleen, Tim, and Shinawat, for agreeing to be a part of this discussion. I'm hopeful that this furthers the conversation on antitrust jurisprudence, be it in the US or let us say in the EU or let us say in the Asian context. So yeah, thank you so much for agreeing to be a part of this panel and sharing your detailed thoughts on the judgment and underlying issues. Thank you so much.
Thank you.
Thank you so much. Thank you.
Thanks very much. Bye-bye.
Bye. Bye.